we're going to move on to session 7 on privileges and members' interests. Honorable Speaker.
Thank you, Madam Chair. Honorable members, this is a very interesting topic for me, and I hope to share my very many experiences with this matter of privileges and members' interests with you. I first want to quote Mays in part because it sets the tone in the sense that a lot of parliaments derive their privileges from the Westminster model, and in some cases even oversubscribe the privileges that they think they have. So, according to Erskine May's parliamentary practice, and I'm quoting here, parliamentary privilege is the sum of the peculiar rights enjoyed by each house. Well, of course, as I say, there are 2 houses in Britain, as you know, collectively as a constituent part of the High Court of Parliament and by members of each house individually, without which they could not discharge their functions and which exceed those possessed by other bodies or individuals. Thus, privilege, though part of the law of the land, is to a certain extent an exempt from the general law. Certain rights and immunities, such as freedom from arrest or freedom of speech, belong primarily to individual members of each house and exist because the house cannot perform its functions without unimpeded use of the services of its members. And Mays continues, when any of these rights and immunities is disregarded or attacked, the offense is called a breach of privilege and is punishable under the law of Parliament. Each house also claims the right to punish as contempt actions which, while not breaches of any specific privilege, obstruct or impede the performance of its functions, or are offenses against its authority or dignity, such as disobedience to its legitimate commands or libels upon itself, its members, or its officers. The power to punish for contempt has been judicially considered to be inherent in each House of Parliament. Now, the whole issue of privileges, though, is fraught with pitfalls as to the extent to which these privileges apply to the colonies and former colonies, and also the degree, level, and severity of the sanctions, particularly for contempt, as I will show. Trinidad and Tobago has what is called privileges legislation. I obtained copies of the privileges legislation. As far as I know, Trinidad may be the only Caribbean jurisdiction that has these privileges enshrined in legislation. And I'm going to leave a copy with your clerk so that you can peruse if you wish. It's called the House of Representatives Powers and Privileges Act. And it is number 3 of 1953, which means it is a creature pre-independence era. Of course, you would have imagined it has been revised and so on and included in later as the laws of the land have been revised. Now, while Dominica does not have a Privileges Act, Section 43 of the Constitution bestows privileges on the Parliament, and it does so in the words, without prejudice, that's Section 43 of the Dominica Constitution, without prejudice to any provisions made by Parliament relating to the powers, privileges, and immunities of the House and its committees, of the privileges and immunities of the members and officers of the House and of other persons concerned in the business of the House or its committees, no civil or criminal proceedings may be instituted against any member of the House for words spoken before or written in a report to the House or a committee thereof, or by reason of any matter or thing brought before them therein by petition, bill, resolution, motion, or otherwise. But if I may just briefly go through the Trinidad legislation and compare it to what is in force in the United Kingdom, there are similarities in the sense of the offenses and the penalties. At section 3 it says that, similar to our constitution, no civil or criminal proceedings may be instituted against any members for words spoken before or written to in a report to the House or to a committee by reason of any matter or thing brought before him therein by petition, bill, resolution, motion, or otherwise. Okay? So that is, we have that as well in our constitution. But then there is this, focusing on the privilege. No member shall be liable to arrest for any civil debt except a debt in the contraction of which constitutes a criminal offense whilst going to, attending at, or returning from a sitting of the House or any committee. Now, there are other provisions that I will not entertain at this time, but I want to focus now on the offenses and the penalties. And basically it says, any person who enters or attempts to enter the precincts of the House in contravention to any order of the Speaker, fails or refuses to withdraw from the precincts of the House when ordered to withdraw therefrom by the Speaker, contravenes any rule made by the Speaker under the standing orders, or attends any sitting of the House or any committee as the representative of a journal or newspaper after the general permission granted under the standing orders to the representative or representatives of that journal or newspaper has been revoked, is liable on summary conviction to a fine of $500 and to imprisonment for 3 months. Now, what is unique here, you will see after, is the fact that there is a sanction that includes imprisonment. And also, I want to refer you to two things. The fact that before any prosecution for an offense under this act shall be instituted, there must be a written sanction from the Director of Public Prosecutions. In other words, the Director of Public Prosecutions of Trinidad and Tobago has to be informed of whatever offense or breach there has been, and he has to, in writing, sanction that the prosecution can continue. And also, the Attorney General has a role to play, because anytime there's a fine or any such anytime there's a fine that has been incurred, the Attorney General may sue for and recover any fine incurred or sum forfeited by any person under this Act, as though the fine or sum were a debt due to the state, and no person other than the Attorney General shall sue for or recover any such fine or sum. And any such fine or sum shall, when recovered, be paid into the public funds. So that is very specific, and so it sort of encapsulates what really goes on in the British Parliament. In real life for us, other jurisdictions, we have to deal with it differently, and so we have a lot of case law. Again, but before I do, let me quote Mays again. Although the privilege of freedom of speech protects what is said in debate in either house, this privilege does not to the same degree apply to the publications of debates or proceedings outside Parliament, but the publication, whether by order of the House or not, of a fair and accurate account of a debate in either house is protected by the same principle as that which protects fair reports of proceedings in courts of justice, that the advantage to the public outweighs and disadvantages to individuals unless malice is proved. This is a matter of law rather than parliamentary privilege. Now, there have been several cases which have been instituted dealing with privileges. The seminal case is Doyle and Faulkner, which came from Dominica. And it has been addressed and, if you like, the courts don't like you to use this word, but it applies, regurgitated in many other cases, starting in one, I think, in 1977, which is a case from Guyana. Now, I want to go to the case of which I'm very familiar, and it is the Herbert Sabruch, which is a member for the Collioure constituency and the Speaker of the House of Dominica. And in it, of course, they refer to the same case which I'm telling you about, which is Doyle and Faulkner, which is an 1866 case, which can be found in the law reports back then. It actually went to the Privy Council. Now, I'll deal first of all with the case of Mr. Sabruch. In 1995, Mr. Sabruch was elected a member of the House of Assembly in Dominica. And on the 24th of February, 1997, during his contribution to an ongoing debate in the House of Assembly, the appellant said to the Honorable Minister for Communications and Works, "On visiting the road on Saturday, 22nd February, I was a little taken aback that the road had not been fixed. Mr. Speaker, because the people of Collioure and the people of Salisbury and the people of Monrachet, these are three little villages, Colibistri and Dublin, they confronted the Minister for Communications and Works on the same feeder road that Honorable Williams had made statements to the effect that the road was repaired. I am talking about a feeder road in Collioure, and I'm wondering why parliamentarians have to behave in public like that. The people, the farmers were asking about the feeder road, and you should hear. I cannot repeat it in this house. You should hear the kind of language that the Honorable Minister used to those poor farmers. It was a big shame. And not that, even in my presence, no one told me I was there. I can call names of other persons who were there. You all must admonish him on that. It is a shame for government ministers to be behaving like that in public when the people are asking them about their problems, feeder road problems. We must not tolerate that kind of behavior from ministers of government. And I do not know in what forum we must bring it up, whether it is in this parliament or somewhere else. There must be a code of conduct for the way ministers and government officials behave in public. And I would be happy that he would be here to hear what I am saying so that he could respond to it. There were sides. Mr. Speaker, I will accept that because I recognize that a number of them behave the same way that the Honorable Minister behaved. I can accept that because they will mumble and grumble because that is the same way they behave. And the Honorable Member for Maho, in my presence, used a word to his fellow companion, the Julian Minister from the Carib Reserve, and he cannot deny it. It is this kind of behavior. It has to stop. On the following day, the Tuesday, the Honorable Minister of Communication and Works made reference to the House of Assembly to the appellant's speech and alleged that it was a matter of privilege. He complained that the appellant had used insulting and disrespectful language in relation to him, and the entire incident was untrue. He then expressed an intention to move a motion against the appellant in accordance with Standing Order 44-4 and asked that the appellant apologize. A debate ensued. On Wednesday, 26 February 1997, the minister presented a motion to the House in the following terms. The member for Collioure used offensive, insulting, and disrespectful language, and indulged in personalities in reference to other members of the House, and the Honorable Minister for Communications and Works, by implication, members of the government side of the House. The motion read, be it resolved that the House come to a decision on the alleged fault, and that if proven, the member be suspended for the remainder of this sitting and the next sitting of the House. After the motion was read, the Speaker permitted the Minister and the appellant to speak for 20 minutes each. There was no further debate. The Speaker then said, I have heard what the member has to say. I would not like to compare myself to Pontius Pilate, but the point is that the matter is out of my hands. I wish to wash my hands. The Speaker then went on to say that as judge in that matter, he ought not to take sides, and besides, the responsibility for the decision making rests surely in the hands of the members. He is just there to preside. Finally, the Speaker said, the fact is I did not stop the member. I think he's quoting section 44.4, and he went on to speak. I will not, because he made a long statement, and then he put the motion before the House. It was passed, obviously. The ayes had it, and the appellant was suspended for the remainder of the sitting of the House and the next sitting. The next sitting of the House was on the 13th of March, and while standing outside the House of Assembly building, the appellant was informed by a senior police officer that it was his understanding that the appellant would be allowed to go into the gallery, which is upstairs, but not in the chamber as a member, and that he was prepared to escort him there. The appellant agreed, but on arriving on the steps, he was told that he had no right to be in the gallery. And the inspector went to clarify matters with the Speaker and came back and said the Speaker would not be allowing him inside. He should be escorted outside. Then, of course, the matter went to court, and the judge at first instance said that there should be a declaration that the suspension of the applicant ended when the House adjourned on the 13th of March. Otherwise, the proceeding should be dismissed, and he will hear the parties as to cause. The appellant, of course, appealed because of the fact that, number one, a sitting in the standing orders is just a sitting, and a meeting is a meeting. In fact, I will just brief you on that. And so that was one of the contentions, not the main one, but I just want to put it out of the way. Okay, and a session means the sitting of the House commencing from when it first meets after it dissolves to when the House is prorogued. So a session would be the U. A sitting means the period during which the House is sitting continuously until an adjournment. And then a meeting means when the House meets first until it is adjourned sine die. So there would be an afternoon sitting, a morning sitting, sitting next day. A meeting is the entire period from the starting of the order paper to the sine die. And so this is where there was a little confusion, and that was addressed on appeal. It was not taken up by I don't think the judge himself understood that. Anyway, the two grounds of the appeal were that, on behalf of the appellant, was that the challenge decision on the grounds that the decision is erroneous in point of law because the learned trial judge failed to consider and properly decide the central issue arising in this case, namely, what, if any, are the privileges of the House of Assembly in the absence of specific legislation enacting or prescribing inter alia the privileges of the Parliament, inclusive of the House of Assembly, to punish or suspend for the breach of the privilege. And the learned judge erred in failing to hold the applicant was suspended for breach of a privilege which did not and does not exist in law, and in failing to hold that the words spoken by the appellant did not constitute or amount to a breach of the privileges. And so the judge agreed that these were the two central themes to the appeal, and said, I agree entirely with Mr. Astafan, that these are the issues which fall for determination on this appeal. I deal with the first part of the question. First, in order to do so, it is necessary, in my opinion, that a careful examination of the complaint against the appellant must be addressed. The Minister of Communication and will complain the day after the appellant had spoken that the appellant had used insulting and disrespectful language in relation to him, that the entire incident was untrue. The minister then indicated his intention to move the motion, and the court highlights all the standing orders of that procedure, and goes on to say, from the record, it is obvious that the minister proceeded, or rather brought his complaint in accordance with Standing Order 44 and of Standing Order 44.4 and 44.6. I make two observations having regard to what the appellant said in the House about the minister. What could be regarded as offensive, insulting, or disrespectful? Or was there anything in what the appellant said that could be regarded as imputing improper motives to the minister or indulging in personalities? And he goes on to say, I think not. The words used by the appellant, in my opinion, cannot in the context be regarded as having been offensive, insulted, disrespectful, or imputing improper motives. The appellant was obviously making a complaint against the minister in the House, the proper forum, in my view, of what he perceived to be ungentlemanly conduct towards members of the public. From the records, it does not even seem to me that a complaint by the appellant was investigated, as in my view there ought to have been an investigation when he said that there were other persons present, and he proceeded to name a few of those names of the persons he deemed that were present. Yet the House proceeded along party lines to file him guilty of a breach of privilege. It is interesting to note that if a member uses offensive and insulting or disrespectful language or imputes improper motive, neither Standing Order 44.4 nor Standing Order 44.6 stipulates how the member should be dealt with. There is no doubt about that he can be dealt with under Standing Order 50. In my judgment, offensive and insulting or disrespectful language could be regarded as being objectionable or unparliamentary expressions. And he goes on to say, to state the obvious, it is clear that all these things, i.e., to say that there was use of unparliamentary language, the request by the Speaker for withdrawal of those words, or explaining them, or refusal to offer an apology, and finally the Speaker asked him to withdraw immediately from the House for the remainder of that sitting, must occur during the course of the sitting. And of course, that did not happen. What privilege did the appellant breach? This, in my view, brings me to the analysis of the privileges as they pertain to the House of Assembly of Dominica. And he goes on with the case from Dominica, Thomas William Doyle and George Charles Faulkner. It was there laid down in clear and unambiguous terms that the Legislative Assembly of Dominica does not possess the power of punishing a contempt, though committed in its presence and by one of its members. Such authority does not belong to a colonial House of Assembly. And by analogy to the lex et consuetudo parliamenti, which is inherent in the two houses of parliament in the United Kingdom, or to a court of justice. In that case, Faulkner, a member of the lower house of assembly, during an address in the House, said to the Speaker Doyle, "You are a disgrace to this House." He was called upon by Doyle to apologize. He refused to do so and repeated the same words to the Speaker. The House of Assembly, having called upon Faulkner to apologize, he again refused to do so. He was then held for contempt, and having, whilst in so contempt, interrupted and obstructed the business before the House. It was thereupon resolved that Faulkner, for his disorderly conduct and contempt of the House, be taken to the custody of the Sergeant at Arms. The Speaker, in pursuance of a resolution passed by the House, issued a warrant in pursuance of customs and practice by the House, committed Faulkner to the common gaol jail during the pleasure of the House. The power of arrest for contempt by the House of Assembly of the island of Newfoundland was also called for determination, and this case was cited. And they repeated what Sir James W. Colville said: "The privilege of the House of Commons, that of punishing for contempt, being one belonging to its by virtue of the lex et consuetudo, right, of Parliamentary, which is a law peculiar to and inherent in two houses of Parliament in the United Kingdom. It cannot therefore be inferred from certain powers by the House of Commons by virtue of that ancient usage and prescription that the like powers belong to legislative assemblies of comparable recent creation in the dependencies of the Crown." The same happened in the case in New Zealand and later on. And even as further in Nova Scotia, Canada, in 1878, again, it was said that these privileges, particularly those punishment for the Crown, is not available. And the judge goes on to say, "In light of the authorities referred to above, I entertain absolutely no doubt that a colonial legislature has very limited powers in relation to contempt. Its powers in that regard are only such as are reasonably necessary for the proper exercise of its function and duties as local legislature. What is then the position of the House of Assembly in an independent Commonwealth of Dominica? The learned counsel, Attorney General, argued that privileges of the House of Commons apply to Dominica by virtue of Standing Order 87. And the learned Attorney General also contended that both the decision, Bradlaugh and Gossett and Jagan and others, which I alluded to just now, this is the Guyanese case, that the House can discipline its members for breach of privilege such as disorderly conduct." The judge continues, "In my judgment, standing orders must be differentiated from privileges. Section 52 of the Constitution of Dominica says in part that the House may regulate its own procedure and may in particular make rules for the orderly conduct of its proceedings. This refers to standing orders only. I agree with the submissions of Mr. Astafan, learned counsel for the appellant, that the House of Assembly, being only one of two constituent parts of the Parliament of the Commonwealth of Dominica, has no authority to make any laws prescribing the privileges of the Parliament of Commonwealth of Dominica provided for as an alleged breach of the parliamentary privilege. The authority for making any laws prescribing the privileges of Parliament resides in the Parliament of Dominica under and by virtue of Section 41 of the Constitution, which says that Parliament may make laws for the peace and good government of Dominica." Then the judge points out Section 43, which I just said, without prejudice to any provisions made in Parliament, there are privileges. Now, there is to and froing between the submissions made by the Attorney General on behalf of the Minister and Mr. Astafan on behalf of the Member of Parliament, Mr. Sabruch. But the judge points out, if the appellant was obstructed the proceedings of the House, or if at the time he was speaking he was saying it was considered to be objectionable or unparliamentary, and the Speaker had asked him to withdraw the words and offer an apology, and he had refused to apologize to the House, then they could have proceeded against him for gross disorderly conduct, but that was not the case. The appellant made a speech on the 14th of February, and the minister on the following day went to the House and said he wanted to move against a motion against the appellant. The motion was read by the minister presented the motion, the minister voted on the motion. The minister is a member of the majority party which forms the government. The record shows that the minister presented the petition. He also voted on the petition. I agree with Learned Counsel Astafan's submission that the minister was judge and jury in his own cause. It is my further opinion that the appellant committed no breach of privilege. The words spoken by him could not be regarded as objectionable or unparliamentary. Even if they were, the action should have been taken at the time the words were used. I now address the question of whether the House has jurisdiction to inquire into affairs of the House of Assembly. The court, sorry. Mr. Astafan, learned counsel for the appellant, in his skeletal argument, said that the court had a responsibility and a duty to ensure that every authority, including the House of Assembly, acts in accordance with legislation, statutory rules, and laws. He submitted that the House of Assembly purports to suspend a member for an alleged breach of privilege which does not exist in law, but purports to do so in complete disregard for the very standing orders made by the House. The court is obliged to act and afford the aggrieved member the appropriate relief. With this, I am in full agreement. I shall go further and say that the Constitution of the Commonwealth of Dominica is the supreme law of the land. The House of Assembly gets its authority from the Constitution. The court, being the sentinel of the Constitution, must act and has a duty to act when any authority acts in non-conformity with any rules or laws which it derives under the very Constitution. The judge then quotes a case from South Africa, and he says and cites what the judge said. It does not, however, follow that the Assembly can do so in a manner inconsistent with this Constitution. The exercise of powers conferred on the Assembly remains subject to the Constitution and subject to constitutional review by the courts. With this respect, I accept this is a correct principle in the law on the subject. Mr. Astafan argued that the appellant has a legal right to sit in the House of Assembly unless he is suspended in accordance with the rules or in compliance with standing orders. I accept this argument. Having decided that the appellant's suspension was illegal, the appellant is therefore entitled to a declaration and orders which he seeks. I hereby declare that the appellant's suspension from the House of Assembly of the Commonwealth of Dominica was unlawful. The appellant also has asked for damages in the High Court. Mr. Astafan told this court that the appellant was paid his salary. No evidence was laid as to his loss. I shall therefore award damages in the sum of $500 for his lawful expansion and costs to be agreed. So this is the case which is saying that yes, we have privileges, but they are very circumscribed. Now, the House of Lords, however, has the capacity to fine and confine for matters of privilege, particularly as they relate to the whole question of contempt. As we see here, the question of contempt has to be dealt with in, I don't know if you all have similar provisions, but the whole question of removing a member, we have a series of procedure, rules of order, so that the speaker is a question of naming the member and going through a process. Yes. So what the court is saying is that that is what is open to members, and it's not so much as a contempt per se, but when that contempt can translate into in a way that is preventing the business of the House from continuing. Now, there's another case which I want to bring to your attention, which was even earlier. No, wait a minute. No, later on. And it just tells you how members, when they deal with matters, must be totally au courant with the standing orders so that they can get it right. In this case, the member for Marigot had brought a case against the Speaker of the House, the Attorney General, and a member, Honorable Matthew Walter. What I'm going to do, I'm going to read a newspaper report, and then I will show this. I had the newspaper report right there. 1 second, bear with me. No, that's not it, no. It's supposed to be right there. Okay, there it is. This is a newspaper report, and when I read it, you get a better gist of what transpired. It is entitled, High Court Rules Speaker Was Not in Contempt. High Court Justice Claire Henry Wilson ruled on the 22nd of October 2004 that the Speaker of the House, Honorable Alix Boyd-Knights, was not in contempt on May 27, 2004, when she refused to allow service of a court order upon herself and others when Honorable Julian Prevost, attorney for opposition leader Honorable Edison James, attempted to serve her and other members while Parliament was in session. Custom and common law dictate that no court order can be served within the Parliament, including inside the chamber while Parliament is sitting. And at the time, the Speaker warned Mr. Prevost, the Member of Parliament for the Maho constituency, that he had no permission to do this and ordered him to take his seat. In her judgment, Justice Claire Henry Wilson ruled that the application to punish respondents, the Speaker of the House of Assembly, for contempt is denied, and the interim injunction granted by the court on May 27th is hereby vacated. According to the government press release, the case began on June 23, 2003, when Honorable Edison James, the then leader of the opposition and parliamentary representative for Marigot, made the following statement. Madam Speaker, Honorable Jacinta Banis, in normal times, I would be happy to congratulate you, but these are not normal times in which you are coming to this house. It is a time, for instance, when the people of this country are being kept at bay, at gunpoint, from being at Parliament. So these are not normal times. Police Press Relations Officer, Assistant Superintendent Cyril Collette, subsequently denied that people were being held at bay at gunpoint from coming into Parliament. He stated that none of the police around the Parliament had guns on their person or were armed. Minister of Community Development and Gender Affairs and Information, Honorable Matthew Walter, brought a motion to the House on June 26, 2003, to have the Privileges Committee sit to decide what should be done about the fact that the leader of the House opposition, Honorable Edison James, had made a misleading and untrue statement to Parliament. Before the Privileges Committee could sit, Mr. Prevost, in his capacity as an attorney at law and acting on behalf of Mr. James, took the matter to court to seek judicial review. At the same time, Mr. James also obtained an ex parte injunction preventing the Privileges Committee from sitting until the substantive matter would be heard. When the matter came before Justice Errol Thomas in December of 2003, Mr. Prevost had not filed the case within the stipulated time. Therefore, Justice Thomas dismissed the case and the injunction as well. So that cleared the way, and on December 29, Speaker Alix Boyd-Knights announced in Parliament that because the case and the injunction had been dismissed, the Privileges Committee was now free to do its work. The committee subsequently prepared its report, which was to be presented at this next sitting of Parliament. Mr. Prevost, acting on behalf of Mr. James, went to court and obtained yet another ex parte injunction, this time on May 27, 2004, the very morning that Parliament was going to sit, seeking to prevent the Privileges Committee from laying the report on the table. On May 27th, Mr. Prevost entered Parliament while it was in session, attempting to serve the Speaker and other members on the government side. The Speaker said, "I am sorry, I cannot take this at this time." Mr. Prevost retorted, "What I will do, Madam Speaker, I will serve it on the other persons concerned." There were several heated exchanges between the Speaker and Mr. James and Mr. Prevost. The Speaker of the House then suspended the sitting of the House for 15 minutes to allow members to cool down. Later that morning, the Minister of Health and Social Security, Honorable Herbert Sabruch, tabled the motion. In that ruling, therefore, the court found that Mr. Prevost's service of the court's order of May 27th on the Speaker and various members of the House while in session was without leave of the Speaker and was a breach of its common law privilege and therefore did not constitute proper service. The judge also found that it was within Parliament's power to inquire into whether the statement made by Mr. James was deliberately false and misleading. Additionally, the court found that the referral of the motion of the Privileges Committee for investigation and report was in accordance with the standing orders, and the court saw no reason to interfere. So here you have another type of situation where a member does in fact commit a breach of privilege in that he told an untruth to the House, and although he had attorneys to try to stop the process, that is to get the Privileges Committee to sit and deal with the matter and conduct an investigation. There was an extensive investigation. Members of the public were called and everything. The report prepared. And when they did find out that the report was going to be tabled that day, they ran to the court and got another injunction. And having been barred by the Speaker, in fact ignored by the Speaker on the basis that she felt that that service was wrong and it couldn't be considered to be proper service, and had the member continue to in fact table the report, then they went to court and to get the Speaker to be sanctioned for what they consider to be the contempt of court for not adhering to the order of the court, and the judge ruled that, you know, you can. I mean, I thought that one of the first things you learn in law is the sanctity of the Parliament. So I was really very surprised when Mr. Prevost came. In fact, what he also did was he grabbed hold of the mic and he read the order through the mic, and then he went and he told the court that he brought this is a well-known case for lawyers would know about. Which is the case. One moment. Yes, Kylie and Carson, that is the case that says, you know, that you can't go into Parliament and serve anything. And Kylie and Carson, there's also another case, Avery and Andrews, where in that Avery and Andrews case, what had happened is that although the order was never served on the defendants, they had notice what they call notice or constructive notice. So in fact, what the court said is that even if there was notice by virtue of you taking a mic, the area in which you purported to give the notice was also a no-no. So you can't say you gave notice. So that is why, the whole case was thrown out. So there you have the idea that although there are privileges attached to what former colonial and quote-unquote colonial parliaments, they are very prescribed. And yes, the courts reserve the right to inquire into the areas where the procedure that has been adopted is incorrect. In other words, what the court is saying is, if you take on powers, or you think you have powers to do certain things, and you do them, and you actually don't have these powers, the court can come in and say, no, you don't have these powers. Compare that now with another situation, which I didn't bring the case, but it's to do with the fact that members asked a question, and at the time the speaker deemed that the question was out of order, so it never went on the order paper. But the member purported to read the question, not what was allowed on the order paper, but what he had originally submitted, and he was told he can't do that, and he was asked to stop. He didn't stop. The members were named. They were thrown out of the house on the basis. And I think what shocked the members was when they found out that, well, when you're suspended from the house, you don't get a salary. So, I mean, members do a lot of stuff, but when it may hurt their reputation. But I think members, my perception is that members seem to care more about their pockets than their reputation. So that, they quickly decided this. They went to the courts. The court said, no, the standing orders is there. If you're suspended, you first have to. The first hurdle for you is to say that you were wrongly suspended. When you prove that you were wrongly suspended, then you can get your salary, your back pay, as it were, But once you are out, you don't get a salary. Well, when the substantive matter was heard, the speaker was found to have acted correctly in all cases, so there was no back pay to be had. And it was very instructive and extremely helpful. From the time the speaker says no, member, please take your seat. You're not going to take your seat. Sergeant at arms. Well, that's it. Members go out. So that tussle that we had that time, we don't have it anymore. Which is a pity because in a house where you have so few members, every member is needed to carry out the work of the parliament, Now, there's one other matter which I want to draw your attention at, and perhaps members can be guided by this, because this is the proper way in which censure can be brought. And I'm reading from the Hansard, Dominica Hansard of, let me get the date. Oh yes, it is of May 1992. Now, what had happened was that the Honorable Prime Minister had brought a motion of censure, or had threatened to bring a motion of censure against 3 members of parliament and a newspaper, of an opposition newspaper, because of the fact that they had made a broadcast. They had broadcasted things which were not said in the House. They had interpreted things that were said into the House wrongly, and that had been brought to the attention of the Speaker. And the Prime Minister had asked that the members apologize to the Speaker and the House, failure of which they would bring a motion of censure against them for that conduct. Well, the members didn't do so right away, but when the House resumed after the morning suspension to the afternoon, the members did in fact offer their apologies to the Speaker and the House. However, as it related to the newspaper, the motion of censure was brought, and as a result of that, the newspaper was prohibited from going to the Parliament for a particular time. The motion of censure was read in the House. The question was proposed, no debate took place, and it was resolved that the Voice of the People newspaper be censured for its behavior and its representative barred from attending the meetings of the House of Assembly for the rest of the year. And the clerk was ordered to convey that decision to the newspaper. Now, I brought this up because, you know, when things get heated in the House, as they sometimes do, members say things and steps are taken which are contrary to the rules. And so it is good for a sort of what should I say? A protocol to be developed, and members bear it in mind. What happens when these things happen, so that members know. In our jurisdiction, we've done so that we don't fall afoul. After the Sabroch case, you know, I said, no, we don't want that to happen to us. So we know exactly, and anything that happens, the clerk will just pull it up, and members know this step one, a member draws to the Speaker's attention that such a member has done something. Step two, the Speaker names the member by name. Step three, the member is cautioned. Step four, the member is asked to leave if he doesn't leave, you know, and so on. And so if this is done, it prevents procedural errors from taking place, as is so often done. I was recently in another jurisdiction, and I was traveling in a taxi, and the Parliament was coming over the radio. The taxi had it on, and it is where a member, when after the House had been suspended, the member, while walking out, said something very derogatory against the Speaker. And so when the House resumed in the afternoon, the Speaker insisted that the member apologize. The member took the view that that was not in the chamber, so therefore the Speaker could not sanction him. But the Speaker had received legal opinion that she could, and they went through the process. In fact, they called me and I told them, well, look, I really don't want to get involved, but this is the procedure that we use in cases like this. The only difference being that you have to be careful how you deal with matters that are said in the House. There's a difference from matters that are said outside the House. And that is why I brought this particular one up, because it was things that members said. What had happened in that case was that there was a meeting of the House. There was a to-in and fro-in between the Prime Minister and a member of the opposition. And the members of the opposition went out and said erroneously, I mean, they gave a totally different version of what the Hansard had recorded and what the tape recording had. And in those days, I mean, no, that wouldn't happen, because they know very well that in a matter of a second, you can say exactly what was said. You can get the recording. I mean, it's all over. So, but that was back in 1992, I think, and so that was what was happening then. So when the Prime Minister heard about it, she cautioned them. Now there's a similar thing that is happening right now. And again, that member is being put before the Privileges Committee. In that instance, last sitting of the House, a minister got up to speak, and while he was speaking, he spoke of the new leader of the opposition, who is not a member of the party. He's a leader of, I shouldn't say so, he's the leader of the party. He's not the leader of the opposition because he's not in the House. That he doesn't even have a GCE, and so even if he has investigative skills, he still couldn't be a police officer because police officers are required to have 4 GCEs and he has none. And somebody in the background said, yes, that refers to so-and-so. He can't even be a police officer and then he wants to be Prime Minister. The member for Roseau went on radio and said, I, the speaker, was the one who said so. When in fact, I was not even in the chamber at the time because my knees were really bad and I had to be getting up because of the air conditioning. So I was outside. When the member was told by a reporter, that, you know, you made a mistake, he says, oh, she would say something like that. So when we came back to the House, I reported it to the members and I said, well, the Privileges Committee is going to have work to do. Now, I have to go aside and tell you that the opposition decided that they're not putting any members before the Privileges Committee. So currently, the Privileges Committee comprises of 2 members of the opposition and the Speaker. What perhaps the opposition may have overlooked is that the quorum is 2. So there are 2 members anyway, and the Privileges Committee can in fact meet, which it will be meeting. The formality will be dealt with at the next sitting. But I have to tell you, I receive legal advice and I am dealing with the matter outside of the Parliament as well, because I think, you know, I don't know about here, but the radio, the airwaves are awash with all sorts of things going on now. I don't know, talk about free speech and talk is cheap, and it's just gotten out of hand in many of the islands, Dominica particularly. I would imagine so, because it's just that everybody has access to the media now, and they don't care. They say anything that comes in their head. I mean, I actually withdrew from being nominated as president because of all of this. I just said, look, I want no part of this, too much. But I feel I have a duty to make an example of members, because to me, they put this, when you set yourself up as a member of Parliament, I think you set yourself up as to a different standard from the rest of the populace. And you are held up as an example to the members of the public, and I think you ought to discharge your functions and whatever you say accordingly. So this is what is all about. Yes, members have privilege. You can say what you wish in the House pretty much as long as the Speaker gets you. You may commit you may say something which in another forum would be a libel or slander. Now, there's one other aspect to all of this which many parliaments overlook, and it is this. I think Dominica is the only jurisdiction that has a parliamentary broadcast committee, parliamentary broadcast legislation. She brought it for me. Where is it, we actually have legislation. It's called the Parliamentary Proceedings Broadcast Act, and it is since 1974 when the radio station started broadcasting live parliamentary proceedings gavel to gavel. Now, as members know by now, you have freedom of speech and you're covered by privilege. But the question arises, when the radio does that broadcast, is that privilege flowing with your broadcast? And so the government of the day saw it fit to introduce this Parliamentary Proceedings Broadcast Act. And there's also a Parliamentary Proceedings Committee chaired by the Speaker. And so it says here in the Act, the committee shall consist of the Speaker of the House, who shall be the chairman, the Attorney General or member of the Attorney General's staff, the Public Relations Officer of the government, and 2 elected members of the House appointed from among the parties present in the House. Now, this, therefore, allows the broadcast to obtain the same privileges that parliamentarians enjoy. And it says here, no action or proceeding, civil or criminal, shall lie against any member of the committee or against any person for broadcasting any speech made in any proceedings. And so the broadcast station, once it relays it, is covered by the same privilege. And that is, but now you fast forward now, that was in 1978. Fast forward now to 2013, where the proliferation of radio stations. I mean, we have radio stations that sit under mango trees and they call themselves Radio Aba Mango, which means radio under the mango tree. That's the name of the radio stations. And they're FM, mind you. And you have all, there's Posse Vibes and Inside Posse, there's 2 of them there, and all over. Now the question arises, when these radio stations, basically what they do is pirate and take it off the authorized radio station, are they covered by the privilege? That is the point. And so now that we are televising, I wrote an opinion, and we, the Attorney General's office and the 2 television stations attorneys, we all had a meeting and we all wrote opinions to say that once Government Information Service broadcasts the do the televising and they put it on their channel in the 2 radio stations, they are also covered. So that it now remains to see who of the media is not covered by that privilege. Obviously, those that are not connected with the government. But then there's a further danger, as I pointed out, and it is this. When an entity, be it a radio station, an online newspaper, or even a hard copy newspaper, publishes matters concerning the Parliament, if they express an opinion, they had better be very careful that it is what is called fair comment. Otherwise, they can also be censured. And it is also true that when they are making their reports, the report must be accurate. Otherwise, they too can be censured. Because privilege goes along with the members' interests. And obviously, where reports are made that are untrue, where commentary is made that is unfair, it all goes against the interests of the members. So it is not just the Speaker who has the responsibility, as well as the clerk, to ensure that all that is said and done in Parliament is accurately reported. For the members' sake and for their own interests, they also have a duty to safeguard the rights and privileges of the Parliament that they enjoy by ensuring that due respect and deference is given to the privilege that they enjoy. Thank you. Section 26 of what? Oh, you have one too? Oh, but I asked and I was told no. Just, just no. Thank you. Oh, can I get a copy of that? I see. Thank you. I didn't understand the last part. Can you repeat, please? Yes. Right. In Trinidad is the DPP. Yes. 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 But I don't know that judicial review would not lie against the Attorney General.
Right, right,
Well,
right. I think a common misconception that increasingly needs to be, people need to be disabused of is that if they act, regardless of whatever authority or autonomy the,
think they have.
the entity has, if they act outside the law,
That's right.
they become subject to challenge. You know, um, I've heard in the years I've been here, I've heard many members stand up and speak into these things and talk about Parliament being supreme, and therefore Parliament can do whatever it wants. To start with, we we do not have, this Parliament does not have inherent powers and jurisdiction. It has that which is conferred to it under the Constitution, and that Constitution is, we're not a sovereign nation to start with, so we're subject to the United Kingdom in that respect. But even within the confines of the Constitution and of the immunities, powers and privileges law, if you act, if the Speaker acts or members act outside these provisions and make decisions, those decisions become susceptible to challenge by in the courts.
This is exactly it. I think no matter how wide your powers, there comes a time that you may be acting outside of those powers, and then the courts can intervene. I mean, this is a very important concept, this idea of separation of powers. Because in our system of governance, this is where the checks and balances come from, you know. And just as an aside, whereas Caribbean people, mainly through misguided other persons, have decided that since the Caribbean Court of Justice members are selected by what they think is politicians, they consider that the CCJ is a no-no. Now, that is another debate completely. But it is the same erroneous type of information that leads to people, the populace, misunderstanding things. I mean, in the case of the role of the parliament, the parliament is there to make laws and whatever. But then you have the judiciary that will step in if the laws that are made are unconstitutional. Because in Britain, parliament may be supreme, but in our neck of the woods, it is the constitution that is the supreme law. And that is a big difference. Oh, yes, that's right. Pardon? Yes, you see, and then you have the executive that is performing a function, and oversight is given to the legislature. Where the legislature, by virtue of these same committees that we've been speaking about, fall short of doing their due diligence, then you cannot blame the system if one of the arms of government fail to carry out their duties. It's all there. But then again, they say that power corrupts and absolute power corrupts absolutely. That is probably because the absolute power comes in when people give themselves more powers than they have. And so this is when the judiciary arm steps in to make sure that that is curbed. Now, if, for example, as you just said, an attorney general decides to deprive that measure of checks and balance from going forward, to me, he is creating the beginnings of constitutional crisis, because he's done it once, he may do it again, and then the whole thing breaks down. You know, we really have to call the different elements in our society to account, and account seriously. And that is no less so with the whole media that has just gone out of control. I mean, things have to be brought back to some semblance of order. Well, this is what I'm saying. I mean, no, we've got to do what we have to do, because, you know, I'm seeing that when you read about world history and world events, you know, the breakdown of society is something that creeps up, you know. It's just creeping. All of a sudden, it just flares up in your face. And the signs are always there. Exactly. And so, you know, sometimes you have to step back and say, look, I mean, as I say, this business of maligning and libeling and slandering is going to stop with me. Over what happened to me over the past few months when I decided to withdraw from putting my name down for president, there's so much I'm suing every last one of them. I may invite you to come on the cruise and all when I get that money. No, and I'm not doing it, honestly, I'm not doing it for the money. I'm doing it because this thing has gotten out of hand. People go on the radio and they say anything. Well, yes, but you see, the anonymity that they think they have, they don't have it. About 2 years ago, it was drawn to my attention that an internet blog was saying things about me. I mean, I don't even know what they were talking about, you know, making all sorts. So it helps if the countries pass the necessary legislation that obliges the person in control of that blog to give out, because they know the IP address, they know everything, and they can give it. In that case, the guy was so frightened, he gave it to my lawyer. My lawyer wrote the man, all the man said was, "Mr. Knights, how much you want, please, and don't make it too much, no?" I just got a little something from him and I give it to charity. I just wanted to make him know that you just can't do these things. You can't just be going around. And it's the things they say.
I believe that one of the things in our particular jurisdiction is that we probably have more lawyers per capita than the rest of the world, but they all do corporate and finance. They are members of the financial industry. They're not members of the legal authority. So it's very difficult to get lawyers to get involved in this kind of testing of the system to make sure it's safe and secure.
Are you telling me that lawyers that practice, let's say in Jamaica, can come and be called to the bar and do the case? Because, I mean, they have a surplus there. I'm sure they'll be happy to come. They can? So, well, right.
But it's still expensive.
Yeah, but you see, that is the thing that these people bank on. And maybe we should persuade our lawyers. I know there are lots of jurisdictions that don't allow for you to get paid on a contingency basis. I mean, certain jurisdictions don't even permit it. But perhaps we need legislation like that so the lawyer can come and say, well, okay, I'll do the case for you and 50% is mine.
Even getting what you lawyers call it civil.
That's what I'm saying. I'm saying that perhaps we need legislation like that now to allow that.
It's under consideration here.
Yes, because I mean, since the cost is a bar, and those persons who wish to malign people are aware of that, you know, when that is thrown out of the window, because I'm telling you, everybody's gone quiet on me in Dominica. All you hear in his praises, because, I mean, this morning I called and somebody said, you know, Mrs. Knights, the whole program this morning was praising you. I said, Allah be praised. Because because I said so in the media. I said, I'm going to sue every last one of them. Tell them, go and get their money organized. I'm coming at them. I said it a little more saucily than that, so I will tell you. No, but you know, there are lots of things that it doesn't always take legislation to make change. And this is one thing that we have to recognize. The other thing, I'm going to make a general statement now, and that has been my pet subject. I'm digressing a bit, but I think this is important. Take, for instance, our Sexual Offences Act that puts the age of consent at 16. The law does not say who must act, or if any action must take place when a young child of 15 presents herself at the hospital to have a baby. You want more proof that there's been a crime committed? So this is why I'm just telling members here, you are legislators, please ensure that when you are passing your legislation, there is a built-in mechanism within that legislation for enforcement. Because I see it all the time. You have cases under the same Sexual Offences Act. What happens when a mother knows that her friend, quote unquote, is interfering with her daughter? For family finances and for economic reasons, she turns. But she should be made liable. To me, she's more culpable than the man. After all, it's her child. So you have to have that type of. Not only in cases like that, you're dealing now with there's a new thing happening in Dominica now where they take all these photographs and then within days the whole world knows of. It's on Facebook, all kind of thing. We've had the first one was a case of two young girls. One was 14 and one was 15 and a half, performing lewd acts on video, and they were passing it on people's cell phones, and it ended up on the internet. And then the knee-jerking reaction of ladies of Dominica was to put the age of consent up to 18. Now, for the life of me, I still haven't been able to make a connection between children under 16 doing something that the age of consent is 16 right now, and that if you move the age of consent to 18, that's going to arrest that problem. But there you go. Anyway, I don't know what else I can add to the issue of privilege, but suffice it to say that members must apprise themselves of what the privileges are, and certainly, most importantly, get some sort of protocol going so that the Prime Minister can whip it out and say, okay, this is what we're going to do. Members, you know.
There's just one question that I wanted to check what your procedure is. In our standing orders, the speaker, if she tells a member to sit down and he doesn't sit down, as an example, and still continues, she can actually have him leave the chamber for the course of that day. And if he doesn't leave, the sergeant will force him to leave. But if she wants to suspend him, she can't actually suspend him. She has to invite a member of the government.
Yes, and name him and go through that process.
Yours is the same way?
Yes.
Yeah. Okay.
But you see, as I say, when things get heated and everybody gets excited, it's very easy to forget what you're supposed to be doing. And so those recalcitrant members can get away. In fact, the leader of the opposition said at the last meeting of the House, oh, the Privileges Committee have no teeth, man, so do what you want. That is why I tell you, that is because he didn't put 2 members on there, so he figures, but the quorum is 2, so.
I was suspended once. Very proud of that fact, actually.
I've had the unfortunate duty to suspend members of the opposition frequently in my 14 years. But when it was done the last time over a protracted period and salaries were involved, I think that curbed their willingness to subject themselves to being suspended now. So,
I was suspended over a point of principle, so I was very proud of that.
well, principles are strange creatures, you know. Chameleons. I consider principles to be something of akin to chameleons. They can change color and shade so readily.
I think we should thank Madam Speaker for that wonderful presentation. Thank you, Madam Speaker. That brings us to the end of session 7. We're going to break now for lunch and come back at 2 this afternoon for a final session.